Good morning all and welcome to our final webinar for 2020. As is the principle of our firm, this is yet another session to empower you as our clients and colleagues in dealing with an important topic such as the one we will be talking about today, sexual harassment. You're all probably looking forward to the Minister of Finance midterm budget speech at 2 o'clock this afternoon, and we hope that a portion of the speech is dedicated towards gender-based violence. Why have we chosen this topic for the end of the year? Because this is the time when sexual harassment, gender-based violence increases as we move towards the festive season. During COVID, during the lockdown period, we had seen a substantive increase in gender-based violence. Divorce attorneys inform us that the number of divorces have increased substantively. So you may want to ask, how are you going to harass people remotely? My colleagues Imran, Patani and Riola will inform you. As a matter of introduction, Imran, Patani, Bongani, Heda, Jean have recently joined our firm and we are very, very proud to have them. They certainly add some gravitas to our department and a new skill set and new thinking, and we hope you enjoy what they have to say. They have some interesting insights, and at least you won't have to listen to me once again. Thank you. Please enjoy this and wish you well. Thank you, Patani.
Thank you, Adil. I'll be speaking in the first session of the webinar, highlighting what is cybersexual harassment in the new world of work. Much has been said. I'm sure it's become a familiar concept. What is this new world of work? A great part of it is really encompassed in the cyber world of work, no longer reporting to a physical office, but working remotely. As part of my presentation, I will be covering the following topics: cybersexual harassment explained, forms of cybersexual harassment as has been identified by international research, give you common examples of what may constitute cybersexual harassment, go through the main sources of the law on sexual harassment, highlight and discuss employer obligations and liability. My colleague Imran will touch on the legal or court principles that have been outlined in respect of that later on in the webinar. Then finally, deal with harassment outside of the workplace and outside of working hours. There has been a lot of controversy around, while this took place outside the employer's premises, outside of working hours, the employer doesn't have jurisdiction. We will try to clarify that point. Next slide, please. Now, just to kick us off, shockingly, in 2016, about 41% of female internet users reported receiving unsolicited pornographic content, being harassed online, as well as being stalked online. 17% of that number reported that this happened through email in the workplace. This is quite a concern for employers, especially as the globe has moved into a cyber workplace. You may be familiar with some casual comments such as, that's a beautiful dress, it sits well on your body, you look sexy, or that male colleague who keeps on inviting Jane out to drinks or to dinner, or be as direct as saying, I would like you to have something with me. Whilst it may conventionally come across as casual, it has undertones of sexual harassment. We all know the test: unwelcome conduct. It is quite premised on how the recipient receives it. Next slide, please. From international research, it has been acknowledged that little has been done to interrogate the concept of cybersexual harassment. There is quite a plethora of research around the traditional direct face-to-face sexual harassment, but they have come with four interesting concepts that try and categorize what this cybersexual harassment constitutes. In the first instance, they've identified active verbal sexual harassment, which is similar to your traditional direct targeted comments about a person's gender, a person's body, a person's body features, you name it. Then there is passive verbal sexual harassment, which is indirect. It is not as active or as targeted as the active verbal sexual harassment is. It would include things such as sexy boobs, sexy tits as pet names in the workplace, that is. Then we have active graphic sexual harassment, which is content that is transmitted through online media, such as your emails, such as LinkedIn, you name it. Then we have the passive graphic sexual harassment, which occurs indirectly through posting on whatever website, circulating porn content onto a group chat, that is. Next slide, please. In this slide, we have listed some common examples of what would constitute cybersexual harassment. I will not deal with each and every one of them individually. I would like to, however, highlight the quid pro quo sexual harassment. It is not a new concept, especially in South Africa. We have heard of terms such as sex for jobs, sex for training, sex for benefits, sex for promotions. There is an interesting judgment in the next slide, which came from the University of Venda versus Mr. Maluleke, who was a lecturer. 3 victims came forward claiming that he had sexually harassed them. The first complainant said that he had kissed her and touched her buttocks. The second victim said that he tried to solicit sexual favors by offering to pass her in her research topic. When she said no, he gave her a 0 for the module. The third victim was asked out for drinks and directly asked to exchange her body for marks. Now, the court considered the question of whether or not a single isolated act of sexual advances may constitute sexual harassment. The court said that although in respect of the 3 victims, those incidents were isolated and were not repetitive, they did, however, constitute sexual harassment. Accordingly, the court upheld the dismissal of the professor. I will then move on to deal with the sources of law on sexual harassment in South Africa. We are all conversant with the Employment Equity Act, specifically Section 6, which classifies harassment as a form of discrimination. We have the Labor Relations Act, specifically the amended Code of Good Practice on the handling of sexual harassment cases in the workplace. Up until December 2018, there were 2 codes in respect of the same subject matter. The position was, however, clarified in December 2019. We now refer to the latter amended Code of Good Practice. We then have the ILO Discrimination, Employment and Occupation Convention, which classifies sexual harassment as a form of violence against human dignity. Finally, we have the Criminal Law Sexual Offences and Related Matters Amendment Act, which classifies sexual harassment as a form of criminality. Accordingly, a victim may pursue action through avenues availed by the employer, as well as pursue criminal charges against the perpetrator under this act. Next slide, please. In the next slide, we discuss the Code of Good Practice, the draft Code of Good Practice, that is, on the prevention and elimination of violence, and harassment in the world of work. It is still in its draft form and was published for public comment in August 2020. I will not deal with the code in specifics. It's quite broad, or quite detailed rather. I will, however, highlight relevant sections to the topic that we are discussing. In the first instance, the code recognizes cyberbullying, which is the inappropriate use of technology to express violence or harassment through emails, texts, cartoons, memes, or web posts. It also recognizes that this form of impermissible conduct can take place inside and outside of the workplace. Importantly, the code also expressly recognizes violence, online violence, and harassment perpetrated through mobile phones, the apps that are available, your WhatsApp, your LinkedIn, your Instagram, you name it. Internet, social media, as well as email, quite relevant to an employer, because emails are an accepted tool of trade used across different organizations. It also recognizes gender-based violence and harassment, and also same-sex harassment. Now, an interesting concept that has been defined by the draft code is what is world of work. It recognizes two aspects of this content. In the first instance, we have the working environment, which is the physical traditional workplace, where persons are associated with work being done for an employer. In the second instance, it recognizes spaces that link workers to a workplace through technology. This is where your remote working or cyber workplace comes in. It specifically stipulates that through work-related communication and any technology provided by an employer, where this kind of conduct is perpetrated, it would then fall within the ambit of what will hopefully be a code. Now, just to close off on the draft code, a final point that it has made is recognizing a hostile working environment. It has been described as an instance when a person is deprived of their dignity and not tangible benefits. So it seeks to draw a distinction between the quid pro quo sexual harassment, where you give me your body or sexual favor in exchange for something tangible, albeit a promotion, benefit, etc. It distinguishes between that by providing for a hostile workplace environment where your dignity is undermined. In that instance, the perpetrator would make or create an intimidating, hostile, or humiliating environment for his or her victim. I will then move on to discuss an employer's obligations and liability. Liability arising in the context of an employer who fails to deal with sexual harassment complaints that are brought forward by employees. The Code of Good Practice on the handling of sexual harassment cases in the workplace creates an obligation for an employer to deal with complaints that are brought forward immediately. That is the operative word. The code specifically states that as soon as a complaint or allegation is brought to light, an employer has an obligation to investigate the incident or complaint, consult with all the relevant parties, that would be the perpetrator, the victim, and any witnesses that may be available, take steps to address the complaint, as well as to prevent its recurrence in future. Imran will later deal with an interesting case, Liberty versus MM, rendered by the LAC, which dealt with an employer's failure to investigate sexual harassment reports when they were reported. In that case, the complainant or the victim was awarded 250,000 Rand in compensation. In another case, the court awarded a victim 770,000 in compensation where their employer had failed to deal with their complaint. As stated earlier, Imran will deal with the specific content or specific provisions of the Employment Equity Act, as well as case law that has dealt with these principles in much more detail. Next slide, please. Finally, I will deal with the difference between, next slide. Thank you. Finally, in concerning an employer's obligations, I will deal with conduct that takes place outside of the workplace and outside of working hours. There is a couple of cases that have dealt with this concept. What is important to highlight for purposes of today's discussion is the court has made it clear that where conduct where an employer is able to demonstrate that the conduct, even though it takes place outside of the physical workplace or outside of the cyber workplace and outside of working hours, an employer may enjoy jurisdiction over that conduct, that is to take disciplinary action, where it is able to demonstrate a legitimate and direct interest. An immediate example that comes to mind would be where conduct has the potential to place the employer in disrepute. If a manager conducts themselves in this type of way, an employer can validly argue that you are a representative of our brand. We all have heard about the Me Too movements. We've all heard of various movements that have sought to bring to light the sexual harassment or typical conduct that has been perpetrated against women as well as men. And in that instance, an employer can argue that your conduct has placed into disrepute our brand or has the potential to place our brand in disrepute and therefore enjoys jurisdiction over that conduct. Added to that, where conduct outside of the workplace is covered in disciplinary policies of the employer, that can be a further basis to extend the link between the conduct and the employer's jurisdiction. Finally, I will deal with the formal and informal inquiries that may be held where complaints are lodged with an employer. Next slide, please. Next slide. Thank you. Now, in the instance of an employer receiving a complaint, there may be two processes that may be undertaken. In the first process, which is the informal process, it is usually followed when a victim only wants to warn or bring it to the attention of a perpetrator that their conduct is unwelcome and does not seek to take it further. This would usually be a discussion or a form of mediation. It would not involve a lengthy investigation or a typical disciplinary process. In the second instance, an employer may undertake a formal process, which is where you have your investigation being conducted and then followed by a disciplinary process. It is not a requirement to first follow the informal process before going into the formal process. The victim may opt to go through a formal process without exhausting the previous process. In conclusion, it is pertinent that we again state the importance of having policies in place to properly outline what conduct constitutes sexual harassment and what the consequences of that would be. This is also highlighted in the Code of Good Practice, which stresses the importance of having a policy in place and to also communicate that policy. However, even in the absence of a policy, an employee may not claim that their conduct cannot be punished simply because there is no policy in place. The Code of Good Practice does cater for that. Thank you. I will then hand over to Riola.
Thank you, Pretini. I see that there are no questions in the question box, but I did want you to address one of the things that we know about global pandemics is that while Sexual harassment is on the rise, reporting seems to decrease, simply because people are worried about job security and economic circumstances. How can an employer still encourage employees to come forward with reporting sexual harassment and ensuring that even the virtual workplace is a safe workplace, notwithstanding the current economic conditions?
This is where policies, clearly formulated and communicated policies, come into play. And we also need to appreciate the discomfort that comes with this kind of complaint, the sexual nature of this complaint. It may make victims generally feel uncomfortable. What has been seen to work or to offer support to employers has been designating certain people within HR or certain managers as the people responsible for overseeing the sexual harassment policies, creating, for example, a hotline for reporting, creating a safe space, as we would describe it, for victims to come forward, and constantly communicating that the employer is there to ensure that everybody is protected. There is no victimization that's going to befall an employee who comes forward. And importantly, to walk the talk. It is important for employers to do what their policies say will happen if that complaint comes into light. Building that credibility encourages employees, victims, whether male or female, to come forward.
Thank you, Petini. On the last question, if you can please deal with workplace romantic relationships were then turned sour. What does an employer do in such an instance where it's now claimed that in fact the relationship was indeed coerced and it was sexual harassment from the start?
Okay. In that instance, it does become difficult, especially when it's initially reported, but it is not a basis for an employer to simply disregard it as two adults who had a relationship. Where a claim is validly made, there has to be an investigation to try and establish if indeed the conduct complained of did take place. Imran will later on deal with what happens when somebody is falsely accused of sexual harassment. But importantly, an employer has to investigate complaints. It does not matter whether it comes from ex-lovers or people who just happen to have unfortunately had this incident happen to them, but it's very important that it's investigated, and if there is evidence that warrants an inquiry to take place, for that process to be undertaken.
Thank you very much, Petini, for that useful advice. Imran, if you can please take over.
Imran, you're on mute.
Apologies. I wish I had a rand for every time during the course of the lockdown this had happened, and I would certainly be a millionaire by now. So Riola and Petini, thanks for that. There's 4 broad topics that I want to cover during the course of my presentation. The topics, if we can flip across to the next slide, range firstly on a question as to what constitutes employer liability and what is the basis of mitigating an employer's liability. Petini's touched on the topic a bit earlier. I then want to move off and discuss the concept of sexual harassment as a form of unfair discrimination. And does sexual harassment actually constitute a form of unfair discrimination in our law? Then turn across to a topic that does arise every so often in practice, which relates to the question of what happens or what is the consequence for wrongfully accusing a person as a harasser in an instance where there's actually no real evidence to sustain that pursuant to a disciplinary inquiry. Then a topic that hasn't found much traction in South African law is the question of non-disclosure agreements and to what extent those have become weaponized to silence victims of sexual harassment. This has been a huge topic internationally particularly since the Me Too movement, and it's a topic that we will canvass during the course of the presentation this morning. If we can then turn across to the next slide, and just look at some basic stats that relate to issues of sexual harassment in the workplace. The statistics show that between 57% of women and 47% of men, that's a 10% difference between the genders, who claim unwanted advancements during the course of an encounter in the workplace. 26% of women report that it's a superior that's their source of harassment. So the harassment, 26% of that 57% of female employees that suffer a consequence of sexual harassment occur at the hands of a superior employee. For men, intriguingly, the statistics show that about 20% of those advances arise from a subordinate employee and not up the rank. Now, an interesting dynamic that's occurred during the course of COVID, and we've seen it arise from March of this year until this year, and here's one example. About 3 months ago, I get consulted on a matter where a client indicates to us that within a month of the lockdown, because it became absolutely necessary for employees to have access to photocopying machines at home, what the employer had done was made arrangements for photocopying machines to be brought into the homes of employees. All well and good. But like most mechanical pieces of equipment, these things break down. And because there's a breakdown, the employer would then take steps in order to get that repaired at the home of an employee. What occurs during the course of the lockdown, and this is where the issue arose in relation to which we were consulted, was the third-party supplier who'd come into the premises of an employee to repair the equipment had been there on the first occasion, had been a very pleasant individual who'd assisted the employee to get the repairs done. Within a week of the repairs being done, there was a further system failure on the piece of equipment. Coincidentally, the same contractor had come into the premises of the employee to fix it up on the second occasion, no issue. About a month later, that employee then raises a concern in relation to this contractor who arrives at her home, knowing exactly where she lives, and she doesn't live in a gated estate. Those were what we were able to determine, who now starts a series of stalking and harassment of this employee. A number of issues had arisen. The contractor had been into the home of the employee. He'd actually surveyed her entire house. He'd known who'd lived with her and who didn't live with her. On these particular circumstances, the employee had lived on her own. The difficulty that was being experienced is that a contractor was now becoming a stalker, and she was very concerned in relation to issues of sexual harassment. We were consulted in order how to deal with the situation and avoid any potential claims arising. But there's provisions in the Employment Equity Act that specifically provide that this form of conduct would constitute unfair discrimination under the Employment Equity Act, and it took no less than 24 hours in order to get the contractor's employer to have that employee suspended for further investigation in relation to allegations of sexual harassment. So the move out of a physical workplace into a virtual workplace, away and remote, has now come with these sort of consequences. So at this point in time, there's not much statistics in relation to the extent of these forms of harassment, but they certainly coming through as we've seen it over the months. If we can then move across to the next slide. What we've done is look at certain concepts of unwelcome verbal comments and other forms of harassment which we've not made up. And these constitute actual comments that are made in relation to particular judgments that have been reported either in the Labour Court, the Labour Appeal Court, or in CCMA arbitrations. And The first at the top of the slide is a 2014 decision in SA Metal Groups, which is quite a well-reputed judgment of the Labour Court on the topic, where one of the comments made to the employee who was being harassed by her supervisor was that he could not wait for someone to see her strut her stuff. And that was one comment. In the Campbell scientific judgment, which Peteni alluded to a little earlier in her presentation, Mr. Adrian Simmers, who was on a business trip with the subordinate employee, who's referred to as X, indicated to her on a series of issues that he raised with her during the course of that trip. One of the comments that he made to her was, "Do you want a lover tonight?" That was after they had dinner at the end of a workday. In a recent arbitration award in McDonald's and SEMA in 2019, there were a series of inquiries raised by the senior employee to his subordinate on the following basis, where he says, if X being the unidentified employee, he says, if X's partner was satisfied with her performance in bed. Those are the sort of questions that he asked her. He then said to her, when her partner was working on night shift, was she sleeping alone? Then there were numerous occasions where he would then say to SEMA, he'd make reference to her in a vernacular by reference to the term opakile, meaning that she had a voluptuous body. So these are examples of some of the instances of where employees use comments of this instance in order to sexually abuse employees on a verbal basis. The Collier's properties circumstances are quite intriguing. It was an employee on the third day of her employment reporting to her manager. When she comes into his office, he closes the door behind her and he kisses her on the neck. She resists his action, and immediately thereafter, she receives payment for 2 days of work. She was there for 3 days. She gets paid for 2, not for the third, and there's effectively a termination of her employment thereafter. If you can then turn across to the next slide, on a similar trajectory, in a 2016 decision of the High Court in Ikwezi municipality, and this appears on the next slide, is X indicates that she walks into her she walks into the office one morning. She settles down in order to get her day on course. Her manager then walks into her office, greets her as one would do in the ordinary course of a sensible morning. However, he then simply takes it upon himself to bend over. He then places his head over her head, and then he tries to put his tongue into her mouth in order to kiss her. And the evidence in court is that her manager's saliva is eventually found in her mouth. That's how distasteful all of this was. Now, these are examples, as I've said to you, that arise out of judgments in the Labour Court. These are not made up examples. We could probably spend the next half an hour, and I could tell you more crude examples of cases where Peteni, myself, and other colleagues have been involved in, where we've been involved in prosecuting sexual predators on serious issues relating to demands for oral sex, for stripping in the office, for forcing employees to watch pornography. But I'll stop on this note because it's certainly just too early in the morning to have to go down that route. But this should give a taste to anyone as to how serious these issues in relation to sexual harassment can actually get. We can then move across to the next slide and look at this concept of employer liability. Now, the decision of Grobler versus Nespers, which is a decision that goes back to 2004. It's an old decision of the High Court, but it's an extremely important case in our law. It's one that raised eyebrows 16 years ago when the judgment was handed down. The case raised serious eyebrows in the legal fraternity, because what the question related to was, to what extent could an employer be liable on the concept of vicarious liability? And vicarious liability relates to an instance where an employer becomes liable for the misconduct or the wrongful action of its employees during the course and scope of employment. And the question was whether or not an employer could be held vicariously liable under our common law. So this is outside of the employment statutes of the Employment Equity Act in 2004 in terms of our ordinary legal principles for sexual harassment that occurred in the workplace. Now, there were various incidences of sexual harassment over a period in time that was suffered by the employee. And what was probably the most traumatic of incidences for Ms. Grobler, who was the secretary to Mr. Samuels in the NESPA's decision, was when she showed her apartment to him and a firearm was drawn. Now, there was an entire debate as to whether or not what the effect of the firearm was to be in those circumstances. And in the judgment, that became referred to as one of the incidences known as the flat incident. The courts, and all the way up to the Supreme Court of Appeal, were mortally offended by the manner in which an employee in the form of Ms. Grobler had to suffer sexual harassment at the instance of her line manager, that the court found that there needed to be a radical shift in our law for the provision that there would be vicarious liability on the part of an employer, even though sexually harassing an employee was not an activity within the cause and scope of employment. So at the time, 16 years ago, I remember when the judgment was handed down, I had a few less gray hairs than I do today. We sat in a room with a number of my colleagues, and we looked at this judgment, and we debated as to whether or not in the High Court the judgment would be not set aside on appeal by the Supreme Court of Appeal, because the concept of vicarious liability was now being pushed. And not to many people's surprise, the Supreme Court of Appeal accepted that position and upheld the judgment, and that judgment of 16 years ago has now become almost entrenched in our law. So what Grobler did was then to pave the way to hold employers liable for sexual harassment as a form of vicarious liability, or on the principle of vicarious liability, even outside of the principles of the Employment Equity Act, which then brings us to the slide that's up on the screen relating to Section 60 of the Employment Equity Act, which provides that an employer is deemed to contravene the statute where it is proved, number one, that the employee who's the perpetrator contravened the legislation, and the employer failed to take the necessary steps to eliminate the sexual harassment. So that's all that's needed to be proven by the employee. The employee perpetrated a contravention of the Employment Equity Act, and the employer failed to take steps to eliminate that sexual harassment. So an employer is liable to the victim, one, for damages, or for a claim for compensation under the Employment Equity Act. And for anybody that deals with the Employment Equity Act, you'd know that there are two forms of relief under the Act. One is common law damages, which are determined in the ordinary course of the common law principles, and a claim for compensation, as we've become accustomed to, under the labor statutes, which forms another basis for a form of a claim for a breach of the Act. The only basis upon which an employer can prevent liability is that if it is able to prove that it took all steps necessary to prevent the harassment. So that's the basis upon which an employer can look to mitigate its liability under the statute. That having been said, we can then look at the next issue, in the judgment in Liberty Group and Masango. I've got the citation in the Labour Court. Peteni put up the citation in the Labour Appeal Court. The Masango Liberty judgment is as significant as the NESPA's decision of 16 years ago. Why Liberty became important is that in 2017, it was the first case to reach the Labour Appeal Court, which dealt with the provisions of Section 60 of the Employment Equity Act, which we looked at a little earlier on the previous slide. Ms. Masango had suffered the indignity of sexual harassment over a number of years with a number of incidences. What's very significant in this case is she brought the incidences to the attention of the HR department. The judgment makes reference to a Mr. Haynes in HR, who was fully aware of the complaints and the allegations of sexual harassment that were being leveled by Ms. Masango. Even though this had been escalated and brought to the attention of the HR department, no action was taken against the perpetrator. So in the face of this, Ms. Masango then resigns, and ultimately, as you would know, she claimed a constructive dismissal. But in addition to claiming a constructive dismissal, she was then able to pursue a claim under the Employment Equity Act and in terms of the provisions of Section 60. The court ultimately found that Liberty had failed to take steps specifically in terms of Section 60 to protect Ms. Masango when it became aware of her complaints, and it failed in its obligations in terms of the statute to do that. Ultimately, she was awarded 250,000 rand, which in the greater scheme of things is not a large amount, but the 250,000 rand must be seen in the context of what it is that Ms. Masango was actually earning. So the claim in these circumstances under the Employment Equity Act could go up to 24 months of compensation, and in relation to a damages claim could run into the millions of rands depending on the victim and the basis of the damages claim. So employer liability for non-compliance, one with the Employment Equity Act, and a failure to protect against a claim for vicarious liability can come with serious financial risk for a business, minus all the reputational risk that goes along and is associated with any claims or even worse, proven claims of sexual harassment in the workplace. We can then move across to the next issue, which relates to another judgment of 2009, which is a Labour Court decision in perpetrated versus National Commissioner of SA Police Service. This is a useful judgment in relation to setting out the requirements for employer liability. The court sets it out very succinctly in this judgment, and it's a useful point point of reference for anybody that's got a particular interest on this particular aspect of sexual harassment. I'll run through the various issues or requirements for employer liability once more, and you'll be able to see as I go through these elements that to establish liability under the Act is not very difficult. So the first is the sexual harassment conduct complained of was committed by another employee. That's one requirement. Or alternatively, somebody associated with the business, i.e. a contractor, in the example that I referred to earlier in the COVID instance with photocopying machines. Second, that the sexual harassment constitutes unfair discrimination under the Act. Thirdly, that the sexual harassment took place at the workplace or in a COVID situation or in a remote workplace. That, in my view, is not going to be a strict requirement, as the workplace need not necessarily be at the workplace. It could be a remote workplace. It's not what the statute says currently, but in my view, that's how that provision is going to be interpreted. The fourth element is that the alleged sexual harassment was brought to the attention of the employer. So in other words, not to fall foul of the liberty situation. Fifth, the employer was aware of the incident after it was brought to its attention and failed to take action. And the employer then was in a position to take reasonable and practical measures to protect the employee and failed to do so. So once those elements are established, it becomes a hiding to nothing for an employer in relation to defending itself in respect of a claim for sexual harassment. So perpetrator is a useful source in relation to identifying those various points. We can then touch on the next topic of whether sexual harassment actually constitutes a form of unfair discrimination. And not very often do lawyers provide equivocal responses such as yes and no, but this is one instance where the answer to this question, is sexual harassment a form of unfair discrimination? And the answer is yes. For so long, is the employee is able to link the claim of sexual harassment to one of the listed grounds of discrimination under Section 6.1, it constitutes a claim under the Employment Equity Act. Section 6.3 specifically now provides, with the amendments to the Employment Equity Act, that harassment is a form of unfair discrimination which is prohibited. And with the amendments and the provision of these sort of disputes being processed through the CCMA, we've just seen an influx of those sort of claims over the last number of years. The judgment of SEMCA, the LAC judgment in Shoprite Checkers of 2020 is also a useful judgment to have regard to in relation to this concept of sexual harassment as a form of unfair discrimination in the Employment Equity Act. I then want to talk to a different concept, which appears on the next slide, which is a further development on this concept of employer liability. And it's the question of whether class actions would be suited in our law for claims of sexual harassment. Now, minus all of the issues relating to the SABC and the SABC's new white paper on new forms of collecting TV license revenues, what we would recall is in 2019 there was an inquiry that was run by the SABC in order to determine whether there was veracity to a number of claims that were raised by various employees relating to sexual harassment. This gave rise to a harassment inquiry report in 2019, and that report, I haven't seen it. I've tried to access it, but seems at least to be tightly held. Provides instances in relation to sexual harassment in the workplace. We also know publicly that there's been various examples of sexual harassment inquiries that have been run by universities around the country. Now, all of this begs an interesting question as to whether or not this can give rise to a class action. Now, at our previous firm, in the last 2 years, and as a consequence of the Me Too movement, we were asked to assist foreign colleagues in order to ascertain whether or not within various African jurisdictions, and particularly South Africa, whether there was a basis for multinationals to be held liable for sexual harassment on the basis of a class action. This is not a theoretical topic. In my view, it's a matter of time in South Africa that where there are instances of sexual harassment or patterns of sexual harassment in a workplace, that an employer has the potential of facing a class action from harassed employees for such conduct. Now, if we look at Harvey Weinstein as one example, what gets lost in the Weinstein debacle quite often is that the man's misdeeds, more often than not, actually arose out of the workplace. So of the various individuals that he sexually harassed, it actually all arose out of the workplace. And those sort of claims, if they find root in South Africa or in any of the other jurisdictions, and it's interesting to see what class action law looks like across the continent, there is, in my view, a prospect that in time to come, we're likely to see claims of class action for sexual harassment. So this becomes another area of liability for an employer to have regard to. We can then move on to the next concept of what happens in an instance of crying wolf. And again, this is not a theoretical example. The question of crying wolf against an employee who's alleged to be the harasser is a serious allegation, and it comes with disastrous consequences. I've represented at least 2 individuals, senior executives who were alleged to have been involved in sexual harassment. Both of them swore up front in our initial consultations that there was nothing of the sort. It had cost them both an arm and a leg in order to go through processes in order to vindicate themselves, to come to a point where there was a ruling to find that there was no no legitimate claim or no basis upon which a claim for sexual harassment could be made against them. The consequence of that, and I've seen it with individuals, is the mental stress it causes to the individual, what it does to their family lives, and what it does to their reputations. So crying wolf is also not a theoretical concept. And in those instances, there's every likelihood that an employee who makes a false allegation of sexual harassment can be charged for dishonesty in the internal process. And in relation to one of the matters, we in fact insisted on that the employee who charged, the employee initially be charged for dishonesty, and that there be a prosecution of that employee internally, and that there be claims for defamation against the employee. Should the employee lose their job as a consequence, there's a claim for loss of earnings and the like. So there is some level of authority in our law in respect of these claims, and this is an avenue that hasn't seen much limelight as yet, but it is an area of law that will develop with time to come. We can then move across to the next topic, which relates to this concept of non-disclosure agreements. Now, the extent of the usage of non-disclosure agreements, or what we commonly refer to as confidentiality agreements in South Africa, was hot on the heels of the revelations of Harvey Weinstein, what had transpired is that he had often entered into these NDAs to resolve claims of sexual harassment. So where there was a claim of sexual harassment, the employee who alleged the sexual harassment was paid off and the employment was then terminated. Or alternatively, the employee was paid in order to maintain confidentiality in respect of the allegations, and the matters were then brought to an end. As a consequence of Me Too, there was a whole deluge of claims which had arose in circumstances where it was argued by Weinstein's lawyers that those claims could not come to the fore because they were subject to non-disclosure agreements. What that had given rise to, at least in the US and in the UK, in June of last year in the UK, after an extensive parliamentary inquiry in relation to this issue, it was recommended that there be legislation in the United Kingdom that outlaws the conclusions of non-disclosure agreements that restrict the legitimate discussion of unlawful harassment and discrimination in the workplace. So, but for COVID, this form of legislation was hot on the heels in the UK to be promulgated. In the US, at least 2 states, New York and California, provided that there would be a restriction on the use of NDAs in sexual harassment cases unless they were requested by the employee. So unless an employee requested the conclusion of an NDA, an employee who alleged sexual harassment could not be forced to sign such an agreement. Now, this is an area that has not received much attention in South African law, and may be an area under the spotlight in South African law in time to come, and perhaps if there's an uptick in relation to claims for class action litigation. We can then move across to some concluding comments. The discussion that we've had within an hour in relation to sexual harassment is not a novel one. It's not a topic that hasn't been engaged in previously, but what we sought to do was to highlight how intricate this area of law has actually become over the years, and to highlight what exposure claims of sexual harassment can have for an employer where they do arise, not only financially, but also from the perspective of a reputation. The 2018 decision of the Labour Court in Rustenburg Platinum Mine versus UASA and Peterson is probably a good example of how intricate this area of law has actually become. What had happened in this case was that the CCMA Commissioner had found that there was no legitimate claim of sexual harassment that had been raised by the employee, because in the face of the harassment that she'd suffered at the hands of Peterson, she was never equivocal in the sense of saying no. At no stage did she actually say, no, I do not want your unwanted welcomes. She didn't say that. So the commissioner took the view that, well, if the employee didn't do that, well, Peterson, well, certainly didn't perpetrate any form of sexual harassment. The Labour Court was absolutely by the position taken by the commissioner on those facts, and the facts get a little more intricate than that. But the court was mortified that where X in the Peterson case was silent, that silence was never to be construed as consent. And the court came out strongly against the commissioner in that matter, and specifically provided to the CCMA and to all bargaining councils that there was a serious need for the CCMA to ensure specialized training on a continuous basis for commissioners. And I'm going to repeat that because the judgment says two things in relation to its criticism of CCMA commissioners, is that there was an absolute need for the CCMA to ensure specialized training on a continuous basis for commissioners. And secondly, that the case demonstrated a serious disconnect by commissioners between the legal principle and its application in practice. And the reason for that is because the law on the legal principles relating to sexual harassment have actually become quite complicated. So Peteni referred to the amended codes, the new codes, the old codes, and the new code that is yet to be promulgated. So outside of the Employment Equity Act, there's all of these codes of good practice that are stacked up that need to be considered, which creates all of this disconnect between application and the legal principles, which actually make this area quite complicated. I then want to move on to the last slide, and this for me is probably the best remarks made by a judge in relation to the concept of sexual harassment that I've come across. This is a judgment of the Labour Appeal Court in Campbell Scientific in 2015, where the full bench of the Labour Appeal Court said the following, and I'll quote it. It says, at its core, sexual harassment is concerned with the exercise of power and in the main reflects the power relations that exist both in society generally and specifically within a particular workplace. While economic power may underline many instances of harassment, a sexually hostile working environment is often less about the abuse of real economic power and more about the perceived societal power of men over women. This type of power abuse often is exerted by a typically male co-employee and not necessarily a supervisor. Okay. And if you can turn across to the last remaining slide and to this paragraph in the judgment where the court says, by its nature, such harassment creates an offensive and very often intimidating work environment that undermines the dignity, privacy, and integrity of the victim and creates a barrier to substantive equality in the workplace. It is for this reason that this court has characterized it as the most heinous misconduct that plagues a workplace. And that, ladies and gentlemen, in my view, is the best summation that you can have in relation to what sexual harassment actually is in the workplace, because it is, as the court says, the most heinous misconduct that plagues a workplace because of these imbalances that are placed precariously at the hands of an employee. So very quickly, those are the concepts as we thought we'd highlight in relation to this minefield area, but one that unfortunately just never goes away, even in a virtual workplace. And with that, I'll pass on to my colleague Leola.
Thank you, Imran. Imran, just very briefly, in the interest of time, if I could ask you to please address the question. I know it was in Peteni's section, but the distinction between the formal and informal process, and the question is this, that when an employee decides or elects to go through an informal process, but an employer is of the view that the conduct is of such a serious nature that it needs to be dealt with in a more robust fashion, one, is the employer allowed to follow a more robust course of action? And the second part of the question is whether or not there's a reduction in employer liability when an employee elects to follow an informal process and the outcome in the end is not what the employee would have wanted or is not satisfied.
Thanks, Yola. So let's perhaps take the first question. Take the first question first, as it were. The question is a very interesting question because it actually relates to what happens practically and what happens from an evidentiary perspective. The difficulty that an employer often faces that where it takes the view that it's got to take formal action against an employee for the allegations of sexual harassment, and the employee's position is that what should occur is the informal process, is, in my experience, is garnering the assistance of the employee to give evidence in the formal process. That becomes the difficulty. So in all of the instances where I've been involved in matters where employers take the position that it wants to go through the formal process, it's securing the assistance of the employee that becomes difficult, that almost compels the employee then to have to go into the informal process. And typically, I've also found that having regard to the circumstances, employees who've been harassed, and particularly if there's one employee who's been harassed and there aren't other employees that line up in support of that employee with similar sorts of misconduct against the perpetrator, actually find it generally easier to go through the informal process. So in short, it becomes a practical problem in relation to giving evidence. On the second question, with regards to mitigating liability, I can only do one lawyer answer in a day, and that was the one where I said, is sexual harassment a form of unfair discrimination? And I said, absolutely yes. On this question, I can't say yes or no. It actually depends on the circumstances of the case as to whether or not that would limit liability. My gut sense is yes, it creates a basis upon which to present an argument to limit liability for an employer, but it really is very fact dependent. And I hope that somewhat answers the question or assists in answering that question.
Thank you, Imran. It does assist us in answering that question. I'd like to thank both Imran and Phetheni for their insights today and in really helping us navigate what has become a new area of both liability, but also concern in the workplace, because we know that sexual harassment has negative impacts for workplace productivity, but also for employers' reputation as well as their brand. In closing, I would just like to briefly mention the CDH anti-sexual harassment online training tool. So while sexual harassment has gone online, so has our anti-sexual harassment training. It's an interactive tool that has both pictures as well as voiceover. It's incredibly easy to understand. It allows employees to understand, number one, what is sexual harassment, and secondly, what to do should sexual harassment occurs. Now, the training is very balanced in terms of various aspects of gender-based violence or sexual harassment in the workplace. And this is one of the topics that did come up in our question and answer session to say, what happens if it's a female perpetrating the sexual violence? What if it's a member of the LGBTI community who's ordinarily vulnerable, but in this instance is the perpetrator of sexual harassment? What you will find in the training is that there's various scenarios that we go through that looks at sexual harassment more broadly, and is not simply looking at sexual harassment from a male and female perspective. If you'd like any further information on the anti-sexual harassment tool, you're welcome to contact me, and my details will be sent to you together with the recording of the webinar and the slides from today. Thank you for joining us for our October edition of our monthly webinars, and we will look forward to hosting you in November. Thank you.